Friends, artificial intelligence and the capability that artificial intelligence brings on the table is known to everybody. And this information and this expectation and the excitement has become exponentially large with the announcement of DeepSeek models, which brings the processing capability of AI LLM to a form factor which is very, very small, which does not have high-end processing power. For example, mobile devices. This I already have stated in a video which I did a couple of days back. Now, friends, this is not about AI video, right? This is not an AI video. Through this video, I am going to raise some fundamental questions which were being discussed since time memorial when privacy law was in the process of developing in our country. That is where my focus would be, and I will refer to the documents which are currently being discussed so that the rules can be finalized. You know that the draft rules of privacy is already out, and those rules are currently being discussed, and then these privacy rules are going to become law. And everybody is quite excited about it because after the act came in 2023, we have now released our draft rules and those are getting discussed. Now, friends, you will find this video very, very exciting, and I think it will trigger a debate. That is the whole purpose of this video. Friends, when I was going through this act and the proposed rules, one thing caught my attention. And that is about processing of personal data within the country and not taking personal data out from the country from the purpose of processing, which is called data localization. Now, if you look at, this is the act. This is the act, Digital Personal Data Protection Act, and I am straight in clause number 16.1, which says central government may by notification restrict transfer of personal data by data fiduciary for processing to such countries and territories outside India as may be notified. So this is processing of personal data outside India. Now, friends, the question that I was asking myself, is it anyway relevant now with AI coming in being? And you will find this question very, very important for everyone to ask. And why I am saying this? The reason I am saying this is, and I will go in detail into each and every word of the act as well as on the rules so that you understand why I am asking this question. The reason I am asking this question is that currently the data which is stored in our phone or we use our phone for various purposes can be processed right within our phone to deliver various services. You know about Apple Intelligence, Microsoft Copilot. All these have AI agent running on your phone. They don't need your data to be taken out of the country to be processed outside the country, which was the case maybe a few years earlier. Now it is being processed right on your fingertips on the phone for delivering services or maybe giving you capabilities which you could not have got without this AI agent running in the background, right? So what does it mean? It basically means that data is not required to be taken out from the country to deliver certain capabilities which can be done using those AI agents. Now, those AI agents are located right in the phone and it is continuously in the process of learning and knowing you better. Means you say something, it will hear. You see something, it will see. You do anything, it will do the same thing. It is something which is living side on your side on a continuous basis and learning your habits and then delivering some of the application which is specifically tailored to your habits. Now, this is the point of discussion, and let me tell you why it will become very, very relevant. Now, look at all the definition which are laid out in the act as well as in the rule. Now, before I get into the definition, let me tell you the risk. These AI agents are controlled by their parent companies because they are right on the phone, delivered by the operating system and the downloads which you do. So they are residing on the phone. Now, they are claiming that the data that is residing on your phone, your identity, your information, those will not get transmitted out of the phone. That is the claim, and I agree with their claim. They may be telling the truth, and they are probably telling the truth. But the inferences can get out of your phone. Means, whatever inferences that application or that LLM is extracting from your behavior, that is an inference, that is not personal data. That inference can get out of the phone into the parent company's server for making judgment about your behavior, which they would have done otherwise by taking the personal data in the cloud, which is located in that country, processed it to get the judgment of your behavior, which now they can do without taking the data out of the country. You understand what I'm trying to say and why this discussion is so important? That is where the key part of the discussion would be, and let's understand what is there in the act and what is there in the rules. Can this be prevented? Can this be restricted? Does it pose a security risk? And what Justice Krishna's report said and why he wanted data localization from the point of view of implementation, what logic was used, those logics are relevant today or not. That is what we are going to discuss. So let's go to the act, one by one. What is data? The definition of data in the act is given. Data means representation of information, fact, concept, opinion, instruction in a manner suitable for personal communication, interpretation, or processing by human being for auto. Everybody understands, there is no problem with that. Data is simply something which is going to give you the capability to identify and interpret the user or the individual. What is personal data? Any data about individual who is identifiable. See, who is identifiable by or relation to such data. So he has to be identifiable. That is data. Personal data means that the individual can be identified. What is processing? Processing in relation to personal data means a wholly or partly automated operation of set of operations performed by digital personal data on digital personal data and includes operations such as collection, recording, organizing, structuring, storage, adaptation, retrieval, use, alignment, combination, indexing, sharing, disclosing, by transmission, dissemination, or otherwise making available, restriction, erase, or destruction. So processing in relation to personal data basically means these things. Now my point is that if somebody is processing personal data on the phone using a large language model, which is curated for the purpose of being running on mobile phones, as the mobile phone becomes more powerful, these models are going to become very powerful. And with the current DeepSeek, with the distillation process, we have already seen that smaller models can be more powerful. My point is that this is processing, right? And you are doing that right on the phone. Inferences out of this processing can it be considered as personal data? That is the question that I'm asking. Inferences, not the personal data. You are not structuring, you are not taking personal data out of the device, but what you are doing, you are drawing inferences, which you would have drawn otherwise by taking personal data and by processing locally within a server inside the country or outside the country, right? It's the whole idea about processing personal data is to either identify the individual or to draw inferences about his habits and behavior. That's all. So here also the same thing is happening. You are processing the personal data within the phone and drawing inferences about that's how the AI agent is able to act in your favor, right? By drawing inferences, correct? So if those inferences get transmitted out of the country, can it be considered as a breach of this act? Can you look at the definition and look at these clauses and tell me whether it is included here or not? I don't know. I am just going through by madly, and I find this clause 16.1 which says central government may by notification restrict the transfer of personal data by data fiduciary for processing to such country or territory outside India as may be so notified. It is only talking about transfer of data, not of inference. Now let's get to the the draft rules. These are the draft rules. Now here, look at this number 4, right? On page number 34, which says significant data fiduciary shall undertake measures to ensure that the personal data specified by the central government on the basis of recommendation of the committee constituted by it is processed subject to the restriction that the personal data and the traffic pertaining data pertaining to this flow is not transferable. So look at this. Traffic data pertaining to its flow is not transferable outside the territory of India. It does not talk about inferences getting transmitted outside India, right? So this is a very important point to be understood and discussed, right? Because let me just go back to Justice Srikrishna's committee report, what he is talking about. Let's look at the committee report. This is where Justice Srikrishna emphasized the need for data localization, because the logic is very important, the context is very important, on which certain recommendations were made and what was the harm that you are trying to prevent. Now the first point here in Justice Srikrishna's report, why he recommended data localization, is basically to prevent jurisdictional conflict. That is what he said. If you see that, this is despite the data being located physically in India, conflict of law might arise if a country of concerned entity or is registration or any other country within which the entity or the claim is substantially connected and also assert its jurisdiction. So it says that then the possibility of a foreign entity refusing access to such data can be reduced if the data is located in India. So the point is that it's saying that avoiding resultant vulnerability also on account of optical fiber cable disruption. It's saying that if there is an optical fiber cable disruption, then also localization of data will help, because there is a huge risk of optical fiber cable cut and your information getting stuck somewhere else and you will not be able to retrieve it. It shows that there has been studies which shows the undersea optical fiber network gets significantly vulnerable to attack. That is the next point of reason why he said that. Then he also goes on to say building an AI ecosystem. He says that the data which is located in India can be leveraged to create an economic potential of an AI ecosystem which is immense. But now the question here is that all over the place Indian data has already been used for developed AI models. There is a lot of litigation which is already going on in the country. You know that, OpenAI versus various stakeholders, right? Now, we are so late with our privacy law that we have already surpassed this risk. It is no longer relevant now. Because one is that there is already a large language model has been developed. There is already debate which is going on. The second is that the processing is no longer required to be at the cloud. It is happening right in the mobile phone and the device where the LLMs are getting hosted. So you don't require processing to be happening at a centralized place. So there is no need for emphasizing on processing. Because people are processing data to draw inferences. How they process, where they process is no longer relevant. Because they are processing that data right in the device which you are using your applications on. Your bank account detail, everything, photos, everything is being seen right by the language model, which actually is running at a par level below the encryption levels of all the peer-to-peer apps like WhatsApp, Signal, any Telegram, anything you use. Before the usage of the apps, before the apps get to encrypt the data you have already given to the large language model which is running on your device. So what is the point of having an end-to-end encryption? Because the device already knows. Now these companies will claim that they are not going to misuse this data, right? That is what they will claim. And they should claim that, because that is the way the business is going to expand. Otherwise, nobody is going to use their intelligence. They will shut off their Apple Intelligence. Is going to be shut off before even if people try their Apple Intelligence, right? Similarly, Copilot will be shut down, right? They will not use, people who are very, concerned about their privacy. So they will keep on saying that they don't like to misuse this particular capability. But my point is that if you look at one particular reference, and I'll give you that US law agencies, right, actually wanted Apple to do this. CSAM detection. And this is a technical paper which Apple had published in August 2021. In this paper, Apple is saying that they have an ability to look at photos in iCloud and your phone to detect, child abuse, right? And that information was made available to the law enforcement agencies in US. Means if Apple wants to develop capability to drive those inferences which are being emanating out of your phone because of the large language model, or Microsoft want to do it, or Google wants to do it, they can very well implement these features which can detect your behavior and alarm law agencies, by drawing inferences because of the processing which is happening right on your phone by these AI models. And that will not take much kind of technical, effort for them to do, because they have already done it. This is already there, and this may not have been, this has been dismantled, probably this has been dismantled, but this capability was already built much before these AI model came into being. So friends, what do you think about this? I just want to throw this idea before you, because I'm not too sure about this, whether the privacy rules of which are being drafted prevents against these kind of eventualities which will happen, because processing is no longer a concern to happen at a centralized place. It is already being processed right on your phone because of the intelligent tools that you will end up using ongoing from here ever, because the phones are going to become more powerful, they will have more resources, they will have better battery, better processing power, and those language models are going to become more powerful. And you will open up all your privacy to those language models without even thinking, and all your apps which are going to run on top of these language models, which will encrypt your data as it goes out of the device. But before you encrypt, that data information is going to be known to those language models, and inferences can get out of your phone to the owners of those language models who are using it in your device to give you those kind of capabilities, right? So friends, I don't know whether I made a wrong inference or not about this risk. You tell me in your comment section what do you think about this, and let me know. If you think that it is otherwise, do also let me know, and I will come back. And thanks for listening, and I'll come back with a new video next time. Thank you very much.